Ever wondered how a contract you didn't sign could impact your rights or obligations? This scenario unpacks the evolution of third-party enforcement in UK contract law, a critical area for legal and business professionals alike. Understanding these nuances is vital for drafting robust agreements and navigating complex disputes. Our journey begins in a modern London law firm, where a family business dispute mirrors classic legal dilemmas. This high-stakes scenario, reminiscent of Suits, illustrates the foundational principle of privity of contract. For law students, this is a cornerstone concept. Sir Edward contracts with Mr. Black for a £1 million payment to his son, Tom, upon his death. When Mr. Black defaults, Tom seeks recourse, only to face a stark legal reality. This case study highlights the practical implications of contractual relationships. The court, citing Tweddle v. Atkinson, 1861, rules against Tom. As a non-party, he lacks the standing to enforce the contract, regardless of the intended benefit. This demonstrates the historical rigidity of privity, a key lesson for contract managers. Decades later, Tom's daughter, Anna, encounters a similar challenge. However, the legal landscape has transformed, offering new avenues for third-party enforcement. This legislative change is crucial for legal professionals to understand. A contract between Anna's mother and a business associate now explicitly states, Anna shall have the right to enforce this term and receive £500,000. This deliberate drafting reflects modern contractual best practices. Anna's lawyer explains the Contracts, Rights of Third Parties, Act 1999. This act allows specific third parties to enforce contract terms, a significant departure from the old common law rule. It's a vital piece of legislation for legal studies. Anna, though not a signatory, is expressly identified in the contract. Her lawyer leverages Section 1(1)(a) of the 1999 Act, which grants enforcement rights if the contract explicitly provides for it. This is a clear example for training purposes. Citing Nisshin Shipping Co. Ltd v. Cleaves & Co. Ltd., 2003, Anna's lawyer argues the express right. The court agrees, confirming Anna's ability to enforce the term. This illustrates the power of precise contractual language. In a parallel scenario, Ben, an employee, seeks a bonus promised in a contract between two companies. He is not named but falls within the class of beneficiaries. This tests the scope of Section 1(1)(b). Ben's lawyer argues that the contract purports to confer a benefit on employees, invoking Section 1(1)(b). Unless the contract expressly excludes third-party rights, the benefit can be enforced. This is a critical distinction for business students. The court rules in Ben's favor, affirming that a third party can enforce a term if it purports to confer a benefit. This demonstrates the Act's broader application beyond expressly named individuals. The evolution from strict privity to the nuanced provisions of the 1999 Act is fundamental for anyone dealing with contracts. Understanding these principles allows for strategic drafting and effective dispute resolution. Actionable insight: review your contracts. Ensure they clearly define or exclude third-party rights to avoid unintended consequences or missed opportunities. Share this analysis with your colleagues and subscribe for more essential legal insights.